Thank you for tuning in to the Behavioral Wealth Consulting Podcast, where our mission is to help you change your behavioral decisions by improving your financial literacy. If you want to live a more fulfilling life and get on track towards your long-term financial goals, it requires changing behaviors, developing a plan, and prioritizing your financial decisions. Now to your host and certified personal finance consultant, Richard Maricut.
Hello, and thank you for joining me today for episode 9. I am your host, Richard Maricut. My goal is to help you change your behavioral decisions by improving your financial literacy. For today's topic, we'll be going over some information on exactly what is a will and why you may need one based on an article written by investorpedia.com. Before we begin, just a reminder, I'm not a financial advisor, and this information is for educational purposes only. Always consult with your own financial advisor before making any financial decisions based on your own situation. So what is a will? A will is a legal document that sets forth your wishes regarding the distribution of your property and the care of minor children, if applicable. If you die without a will, those wishes may not be carried out. Furthermore, your heirs may end up spending a lot of time, money, and emotional energy to settle your affairs after you're gone. That's where wills can vary in their effectiveness depending on the type. Though no document will likely resolve every issue that arises after your death, wills can definitely help keep things organized to the best of its ability. So here's what you need to know about these important documents. Again, we'll go over a little bit more in depth, but one thing to keep in mind is a will is again, legal document that spells out your wishes regarding the care of your children, as well as distribution for your assets after your death. Failure to prepare a will typically leaves decisions about your estate in the hands of either judges and or state officials, and may also cause some family turmoil, right? I think some of you may have seen anytime someone passes, especially if there's assets involved, it can often cause friction between family members because everyone may have their own interpretation of what the person who passed may have wanted their assets to go or how they wanted it divided. You can prepare a valid will yourself, but you should have the document witnessed to decrease the likelihood of a successful challenges later in the year. And then to be completely sure everything is in order, always consider having your will prepared either by a trust and or estate's attorney that specializes in putting wills together. So why should you have a will? Some people think that only the very wealthy or those with complicated assets need wills. However, there are many good reasons for the average person to have a will. So first, you can be clear about who gets your assets. You can decide who gets what and how much. Second thing is you can keep your assets out of the hands of people that you don't want to have them, especially if it's estranged relatives, folks that maybe you just no longer have relationships with. You want to make sure that, again, your assets are kept only into those that you want to receive them. Third is that you can identify who should care for your children. Again, if applicable, if you happen to pass away and you're the only parent, a will helps you ensure that your children are taken care of by the person or persons that you identify that you trust, right? Without a will, this is typically where the courts will decide. The fourth is your heirs will have a faster and easier time getting access to your assets, right? So again, the purpose of the will is to be very concise with your direction. So, assuming at the time you put your will together, you were very thorough in the instructions. This will help your heirs or family members get exactly exactly what you wanted them to get, the amount, types of assets, etc. So there's no misinterpretation of what you would have wanted. And then the fifth thing is you can plan to save your estate money on taxes. You can also give gifts and charitable donations, which can help offset the estate tax. So, some people choose to take their assets and instead of giving them to family members, they may decide to gift some of their assets and or money, again, to charitable organizations. A written witness will is often the best, right? To maximize the likelihood that your wishes will be carried out, you can create what's known as a testamentary will. This is the most familiar type of will because you prepare the document and then you get it signed by a witness in presence, right? It's probably the best insurance against successful challenges to the will, to your wishes by a family member or business associates after you die. You can definitely create one yourself, but if you do go that route, make sure to have it prepared by a trust and or estate attorney for a greater insurance and protection against that. Now, there are other types of wills, inheritance wills. While the testamentary will is likely your best bet, several other types of wills get varying degrees of recognition. The first one is the holographic wills. Wills written and signed by a testator but not witnessed are known as holographic wills. From the less common secondary meaning, the word holographic meaning a document that's handwritten by its author. Such wills are often used when it's time and there's very little time or short notice, and where maybe witnesses are unavailable. For example, would be, if you're trapped in a life-threatening accident, right? So you don't really have time to plan. Holographic wills typically can be used in this type of situation. Now, one thing to keep in mind, however, is holographic wills are sometimes not recognized in all states. In states that permit the documents, the will must meet minimal requirements, such as a proof that the testator wrote it and that he or she had the mental capacity to do so. And even then, the absence of witnesses often leads to challenges to the will's validity, right? Because again, you're doing this without witness presence, and or there might be witnesses, but it might not be someone that would have normally witnessed the will in the first place, again, because of a life-threatening situation, right? So again, although it could be valid in some states, it could also present loopholes in being challenged by family members, again, depending on the situation. The next two types are the oral and pour-over. So the oral will is least widely recognized, in which the testator speaks their wishes before witnesses. So again, they're not writing them down, they're speaking them. Keep in mind, however, when you lack a written record, or at least one prepared by the testator, there's typically challenges that can be presented in courts. And sometimes courts may not even recognize oral wills. So again, depends on the state. So make sure that you do your research based on the state that you live and decide to write your will. The pour-over wills is another type of will, but it is used in conjunction with creating a trust in which your assets flow. So again, not really a standalone. It's more of a addition to. Okay. Lastly, we have a mutual will. So a married or committed couple usually executes this type of will. After one party dies, the remaining party is bound by the terms of the mutual will. These types of wills can be used to ensure that the property passes to the deceased children rather than to a new spouse. Because of state differences in contract law, a mutual will should be established with the legal professional's help. Though the terms sound similar, mutual will should not be confused with a joint will. Again, so if you're in a situation where you're married and or with a business partner, you may want to be very specific and look into getting legal professional help in creating this, so you can make sure that after your passing, that it's not manipulated and or taken into a different context than what you may have originally intended. Now, a joint will is a single document executed by more than one person, typically between spouses, making which does have an effect in relation to his or her death warrant, right? So the will during his or her lifetime, the spouse can challenge. It makes it easier to challenge, I should say, right? So the joint will is a separate distribution of property by each executor and will be treated as such on admission to probate. So what does a will cover? A will allows you to direct, again, how your belongings, such as bank balances, property, or prized possessions, should be distributed. If you have business or investments, you can specify who will receive those assets, when they will receive those assets. Again, so you have very specific direction when it comes to that. A will also allows you to direct assets to charity or charities of your choice. Similarly, if you wish to leave assets to an institution or an organization, a will can assure you that your wishes are carried out. While wills generally address the bulk of your assets, some aren't covered by their directions. So those omissions include payouts from a testator's life insurance policy. Since the policy has specified beneficiaries, those individuals will receive those proceeds. And the same will apply for an investment account that are designated as transfer on death. So in addition to directing your assets, a will states your preferences for who should take over as guardian for your minor children in the event of your death. So, we went over a lot of, what the benefits of a will, right? But now the question, what happens if you don't have a will? So if you die in state, that is without a will, you're opening yourself to the state overseeing your assets being distributed, which will typically be distributed according to a set of very specific formulas in that state. Because of the elective share and community property provisions mentioned, the formula often results in half of your estate or assets going to your spouse, and the other half going to your children. In these type of scenarios, sometimes can result in the sale of a house, the family house, or other assets, which can negatively affect the surviving spouse, who may have continued on as the bulk, the primary person of your assets to maintain the living or standard of living, right? Further complications may ensue, right? If your children are minors, as a court will appoint a representative to look after their best interest. So again, if you don't have a will, you leave those things open for potential judge and or states to become involved. Now, if you're at a point where you're listening to this show and you're wondering, what are the next steps? So there's 8 steps shared by nolo.com, and I'll just go over these to give you an idea of how to get started. So step number 1 is decide, what property and type of assets do you want to include in your will. Number 2 is decide who will inherit your property or assets. 3, choose an executor to handle your estate. 4, choose a guardian for your children, if applicable. 5 is choose someone to manage your children's property, again, if applicable. 6 is make your will, right? So strong recommendation, if you've never done this before, is hire a lawyer. If you do decide to make it yourself, the strong recommendation is to have an estate or a lawyer that specializes in wills to sign over or look over to make sure that it truly would support what your intentions are. Number 7 would be to sign your will in front of witnesses. And finally, number 8 is to ensure that you store your will safely, right? So in the event of your passing, you want to make sure that your will is in the hands of someone who can ensure the instructions are carried out as you designed. So that's it for today's podcast. If you enjoyed today's session, I'd appreciate you giving me a positive rating on whichever podcast platform you are listening to. It does help me get my message out to more users to help improve their financial literacy. And for more information about my services, please visit behavioralwealthconsulting.com. And if you'd like to hear about a specific topic on future episodes, please email me directly at behavioralwealthconsulting@gmail.com. Thank you.
Thanks for listening to the Behavioral Wealth Consulting podcast. For more information on how we can help you design an effective financial strategy through behavioral changes, visit us at behavioralwealthconsulting.com.